Okay, Shannon, put us on. Oh, here's a couple more. Okay, first up is Baker versus Keelhorn.
Thank you, Your Honor.
State your appearances, please.
Randy Hackney on behalf of Dr. Keelhorn and Columbia Medical.
Your Honor, Stephanie Karizny on behalf of Dr. Monfett, Henry Ford, and Independent Emergency Physicians.
Spell that, please.
Karisny.
Thank you.
Correct.
And Mr. Morris, are you here on the Baker versus Keelhorn matter?
No, the Karim Healthcare.
Oh, okay, that's the scheduling conference. All right. Okay, are we expecting any other counsel on the Baker versus Keelhorn matter?
Your Honor, this is Randy Hackney. I would expect so, but I have not heard one way or the other.
Your Honor, I haven't either.
Well, there's nobody else in the waiting room. Is everyone here on the Karim Healthcare matter?
Yes, Your Honor.
All right, I wasn't planning on doing this one on the record, but we're on the record and it's just easier to stay that way. Okay, assuming this got set for a scheduling conference so that I can get on top of the case. This is one where I am actually sitting in Hillsdale. Correct?
Correct.
Okay.
Your Honor, I'm sorry, I didn't hear who was here on this one.
I'm sorry. We need to make sure my clerk can log in. It's a struggle with Zoom because she can't see the screen. So we have Allison Oliver on behalf of which party? Plaintiff?
Plaintiff, Your Honor.
Okay, and Christopher Morris
Correct.
on behalf of the defendants.
Thank you.
Okay, I'm assuming you folks have already started some discovery?
Yes, we've conducted a deposition of the defendants so far in the case.
How much time do you think you're going to need to complete your discovery?
At this point, on behalf of plaintiff, we're satisfied with the discovery that we have.
Okay,
It's a contract case, Your Honor. I don't think we need a lot of discovery here.
all right. Have you considered some form of ADR?
Well, we have exchanged some emails in regards to attempts to settle. On behalf of my client, I can say we're always interested in trying to reach a resolution and would be happy to participate in, non-binding facilitation or something of that nature.
I'm a strong believer in facilitation. Have you discussed that at all yet?
No.
We have not. There are pending summary motions.
Oh, okay. Are those noticed up for hearing sometime in the near future?
They are not.
Are all of the filings complete?
I believe so, yes.
So you just need a hearing date?
Yeah.
Right, and if I may, I don't mean to speak for Mr. Morris, but I know that he would like, if the case isn't resolved on summary, this is a injunction case, and I know that the effort on behalf of defense is to dissolve the temporary restraining order that we have in place, and our effort is to make our temporary restraining order a permanent injunction. So as we sit here today, plaintiff is somewhat satisfied that, you know, the evidentiary hearing has yet to be scheduled, but I know that Mr. Morris feels exactly the opposite.
You know, Your Honor, the court rule is expressly clear that the preliminary injunction hearing should have been held within 14 days of your assignment to the case. You were assigned July 1st, so there is no injunction at this point. If plaintiff wants an injunction, they need to file a motion and have a hearing.
Well, and you know, the last order from the last court continued our TRO until the evidentiary hearing that has yet to be set by this court. So I guess we could argue as to what an order of a previous court means or doesn't mean, but at the end of the day, I think, well, you know, I'm happy to notice up a motion, but, you know, our position is the injunction is in place, and, you know, to the extent defendant would be in violation of it, we would bring contempt proceedings.
Your Honor, let me read the order. The order says, until such time that a hearing can be rescheduled. A hearing could have been rescheduled back in July. It was not. And the court rule is very specific that the burden is on the party seeking the injunction to have the preliminary injunction hearing. They did not. That
Well, we weren't, you know, to be clear, we weren't even aware of this court's appointment within the first 14 days. So that, you know, even if counsel was correct, which he's not, that would be a legal impossibility because we weren't advised until sometime after that time period.
We were advised on September 3rd that this hearing was going to take place today, counsel. I have not seen a motion. That temporary restraining order has expired as a matter of law.
All right, well, I'm not going to hear any more arguments about that this morning. I'm going to give you a hearing date. If there's a question about whether the temporary restraining order is or isn't in place, you can make sure that's properly noticed up and addressed. I typically hear dispositive motions on either Mondays or Wednesdays at 3 o'clock or 3:30. I don't put you on the normal motion call, so I have a little extra time to devote to it. If you want to get with my secretary for civil matters, Patty, she will make sure that whatever date it is that you'd like to have this heard and whatever else needs to be heard, I'm happy to accommodate you. Just get with her. I want to do it all at once. And I'll hear your arguments about whether or not there is or should be a TRO. You know, when I get a file like this from another court, it's just like files that get sent up from downstairs. I don't read those files. I got the file assigned. I agreed to take the assignment. I asked my secretary to schedule a scheduling conference to see where we are, see what needs to be done. If there are matters when a new case gets assigned that you think need to be brought to the judge's attention immediately, I suggest you do that. Don't expect us to sit down and read a file, specifically one as thick as this one is. So find your hearing date, and what I'll do then, if I rule in a way that disposes of the case, then obviously we don't need to worry about ADR or dates or anything of the sort. If I leave the door open to whatever else needs to be resolved, we'll pick some dates then. How's that sound, counsel?
That's good, Your Honor. Thank you.
Sounds good, Your Honor. It's a partial summary disposition anyway, so.
Oh, okay. Well, so it looks like we will be finding some dates then, but that's fine. Let's do it all at once when everything's fresh in my mind.
Very good. Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Thank you. Thank you all. I don't know if Patty holds on to those. They don't go back downstairs.
Okay.
Because it's not a Jackson file, it's a
Okay.
Hillsdale file. Okay, let's go back on Baker versus Keelhorn. No one else has appeared, so I guess I will assume that you are the only counsel that want to advance arguments this morning. I didn't
Just so
remember
that, I'm sorry, Your Honor, this is Randy Hackney. While you were doing the scheduling conference, I asked my office to contact Mr. Turk's office to find out if he was going to appear. We have not received a response.
All right, well, the matter was scheduled for 10 a.m. Let me check my email and just make sure that I haven't received some indication that there's somebody tied up in another court. We've received no communication from anyone, so let's proceed.
Okay,
Whose
Your
motion
Honor,
is this?
This is my motion on behalf of Dr. Keelhorn and Columbia Medical, which is joined by co-defendants.
Go ahead.
And this is our motion really to just compel some discovery. I'm not going to go through the recitation of all of the contacts back and forth that's laid out in the motion. But what we're requesting here is that the court enter an order that requires the plaintiff to produce for deposition prior to October 30th, which is our discovery deadline date. And that's one of the reasons we had to bring this motion, because we keep getting pushed down the road. But we want an order that says, hey, you've got to produce any and all experts that you're going to call at trial regarding causation and damages. And if you don't, those individuals are precluded from testifying at trial.
And is Karisny, are you opposing this?
No, Your Honor, we filed our concurrence in this motion. We concur and join in the relief requested.
And I hesitate to say with any level of confidence that there's been no response to this motion, because unfortunately, it seems to be a pretty common occurrence these days that things get filed but don't make it to my file. Have either of you received any opposition to the motion? Written
I have not.
opposition?
I have not, Your Honor.
No, Your Honor.
All right. That gives me a high level of confidence that nothing was filed. I'm going to grant your motion. Just
Thank you, Your
submit submit your proposed order under the 7-day rule.
All right, we will do so. Thank you very much, Your Honor. Appreciate it.
Thank you both. Have a good day.
You
Thank
too.
you, you too.
Bye-bye.
Bye. This goes in that Hillsdale file. Okay, so I guess we're done until 10:30.
Is anyone appearing in person at 10:30, Judge?
I don't think so.
Okay.
And then I've got the 24-hour hearing that I told them 10:45, but there won't be anybody here live. It's possible a parent might show up.
Sure.
I mean, they're entitled to be here in person if they wish. Okay.
Hey, Judge, can I quick pick your brain on this ordinance?